Our opinion on filing EEO complaints, broken threads of justice, our story, legal analysis, and case law P1. Disclaimer: the following video is based on the personal experience and opinions of one individual based on positive, honorable intentions to simply tell a story, analyze legalities of situations, and provide case law so the audience can be more knowledgeable about EEO processes or determine whether the EEO process is a process that can help them. We are not legal attorneys, and this video is not intended to provide legal advice. We recommend never taking actions based on information found online. Instead, seek help from a licensed attorney who knows your situation. Our personal experiences are based on truthful narrative and integrity-based opinions of one employee with a focus on positive intentions, accuracy, and truths. EEOC case decisions may be complicated and affected by a judge's personal opinions or understandings of the law or case law precedent. We do not wish to affect or harm anyone's reputation. Instead, clarify our story, analysis of law, and analysis of case law so you can understand why we won. Feel the EEO process is broken and a waste of life too. Recommend you quit jobs that are unsafe or unlawful. 3. Expect retaliation in response to filing any complaint or reporting any concern. 4. Expect witnesses to be retaliated against if they chose to support or be a witness to anything. Smash the like button for the YouTube algorithm. Based on our story serving a federal emergency management agency, we are today an appellant to a retaliation case that separately followed an EEO complaint filed in 2019. Within a few months of experiencing a hostile work environment, appellant requested relocation to separate herself from the unlawful activities. The agency relocated individual to a different state where appellant served under a new supervisor who trained the main offender at the previous site. This executive official T.C. stated to the appellant on January 9, 2020, that it took us 3 years to get rid of the last employee who complained. Today, the facts are that the agency did in fact successfully get rid of appellant in just under 3 years. The agency retaliation was pervasive and severe, causing medical issues throughout the 3 years of service. Never did the agency address concerns. Just a few months after the statement, appellant for that 2019 EEO case mailed documentation to file that case to the formal EEO process using the agency mail offices. Appellant realized that the mail was apparently redirected and would never get to the final destination by the due date, so she separately overnight shipped the documents again. When the EEO counselor received the timely submission, this was around February or March, she confirmed receipt and informed appellant that she would rightfully process the timely submission. I clarified my fears about the fact that the agency redirecting my mail, and the EEO counselor voiced her fears that she may lose her job or be retaliated against for rightfully processing and not dropping the EEO complaint. She told appellant in the phone call that she worked for the agency for a long time, would never quit, and loved her job. By August, I discovered that EEO counselor's job ended as she was forced into retirement or terminated. At this point, my complaint was now being managed by her superiors. Smash the like button for the YouTube algorithm. I, during this complaint, had 3 deployments that experienced no retaliation or unlawful activity. These were in Pensacola, Florida, Region 7, and with the Small Business Administration, which is a separate agency entirely. My deployments originally in North Carolina, then relocated to Oklahoma, then Louisiana, all experienced some retaliatory actions and harassment due to my filing of the EEO complaint because T.C. was also deployed or relevant to each of these work opportunities. On January 9, 2020, in Oklahoma, T.C.'s original evaluation stated appellant was a model employee and a positive evaluation was placed to record. Within a month following, the operations chief became involved and the agency started fabricating conduct issues against me. By April, I completed my Region 7 and SBA deployments through around October with only performance evaluations of excellence. Next was Louisiana's deployment, which was mostly remote work and a hostile work environment. Then from February to March, I excelled with an excellent evaluation in Florida, leading into my next position, a promotion to a position in Saipan, Northern Mariana Islands on the other side of the world. Here, I again started fresh, expecting no retaliation, but arrived to permanently replace an experienced specialist who was an older female from my first position in North Carolina. This female, yes, did not pass down the duties effectively and stated, "You will fail here," or similar words. From here, mainland California sent out a specialist to train me in my new permanent senior advisory position and pass down compliance actions I must implement here at this duty location. This California employee female did a great job of objectively clarifying and passing down the needed information throughout my probationary period. Then in late September, she stated, "You do not need me anymore and are doing a good job, so I will return to California and resume my work there." The only problem was May 2021, MJ notified me that the original supervisor for my North Carolina 2019 EEO complaint CK was completing the hiring process to be my boss on this island for appellant's new role. By June 9th, my on-site supervisor and California supervisor were notified that a 2019 EEO complaint between the two individuals may mean a hostile work environment if that individual was hired to be appellant's supervisor again. While this hire of CK never played out, CK worked in California with my California coworkers and superiors June 2021 ongoingly through my resignation. TC from that 2019 EEO complaint similarly worked for my California coworkers and superiors from around July 2021 on, and specifically seeked out the California manager who was training the MJ to talk about me, probably to negatively impact me. But M.J was objective and left on a positive note, leaving me to perform my managerial duties solitarily on the island. By February, I settled the 2019 EEO complaint with the agency because I wanted to move on. The problem is November 3, 2021, appellant was on the radar as a whistleblower by her California executive superiors who on this date placed a negative evaluation of about one sentence and/or negative rating to record in complete contradiction to her on-site supervisor. See lengthy positive evaluation and rating of above average excellence within her duties just several days prior. From here on, appellant was subjected to retaliatory adverse impacts to her job, and these are the events, legal analysis, and case law we will discuss in the next videos. We will analyze all that occurred November 3, 2021, to her eventual resignation July 12, 2022, through continued financial impacts experienced through present, as she today serves as a credentialed contractor for this agency, but never gets opportunities to deploy, likely in retaliation for whistleblowing. Today, this November 2021 case was dismissed by the judge, and appellant filed an appeal. It is this case we clarify and discuss because this case is still processing, and we find no resolution when the facts are clear. Appellant does not believe in the EEO process because employees rarely, if ever, gain just resolutions, especially if they do not have an attorney representing them. Today, the agency did in fact get rid of the employee for complaining. Even though whistleblowing protections exist, the judge today decided in the agency's favor in our eyes because the EEO process is not fair, and the agency successfully combated it by placing exorbitant amounts of resources to get the complaint dismissed and never addressed the concerns and complaints of the employee through present. No amicable remedy was approved in the decision by the EEOC judge. This case decision sets the precedent that a delay of justice, disregard of facts, manipulation of evidence, lack of action by the agency to address complaints, and unlawful actions in general shall prevail entirely without justice. Smash the like button for the YouTube algorithm. Here, evidence: sleepless nights, chronic stress, hives, bacterial infections, positive for COVID-19 with symptoms, immune system issues, and other medical issues, all medically proven to not be a simple allergic reaction, are not deemed pervasive impacts to appellant, nor does her being replaced within her managerial position. Unjustified negative evaluations after repeated exemplary ones, separation from work in April, and forced constructive discharge, and other adverse actions rise to the level of severe or significant enough to warrant the administrative judge to not dismiss this EEO November 2021 complaint. Congratulations, agency. You successfully disregarded claims, evidence, case facts, and accountability for unlawful actions. Here, you all must know, this outcome is likely for you too, especially if you represent yourself within the EEO process. Likely you will waste your life just to gain a dismissal regardless of experiencing multiple adverse actions against you, all of which are evidenced circumstantially and directly. Here, appellant clarifies, you should in my eyes not put up with unlawful activities, instead get a new job and continue your excellence with a new employer. To be your best self, your reputation and who you surround yourself by will affect your ability to find excellence in all you do. If an employer undermines you and takes actions to reduce your duties, demote you, or place to record fabricated information against you when you are always a competent employee who goes above and beyond in all they do, it is always a good choice to end this job for a position that has good values and supports your success within the company. Emotionally, it is very draining to be in an abusive company that disregards the implementation of safety or employment laws in place to protect employees. Do not live in this situation. Change your job and find companies with good values and positions that help you be your best self, grow professionally, and serve in a rewarding career. Forever will my life, career, financial situation, and health be impacted by the 2019 EEO case and 2021 EEO case, with literally never any actions to address issues by the agency and literally a dismissal to resolve the issues by the judge. You have one life and do not get your time or health back. You have one life and do not get your time or health back. This, in my eyes, the eyes of a U.S. Coast Guard Academy veteran graduating top of her class in all her degrees, which include a master's in environmental law and policy from Vermont Law School. This is a story of a broken legal system. One that favors big entities with teams of attorneys who combat complaints for a living. As an employee, good luck getting fair outcomes. Appellant always excels in all she does due to much hard work, a high level of academic intelligence, and the decades of professional experience that began with work starting in 2005, with 7 years of the service being 84-hour work weeks instead of 40-hour normal work weeks. I cannot imagine how easy it is for an agency to fabricate conduct issues against normal average employees who do not have appellant's resume or evaluations of above average excellence. There is a reason pro se gains disfavor able outcomes statistically. There is no fair remedy pro se. Instead, expect some or all claims to be disregarded and dropped as they were for appellant. If your case takes forever, years, to gain a positive outcome, this is not justice. You can die before seeing that outcome. That is not fair. I always say, only file complaints when ethically the issues are severe. Appellant filed these complaints because she admired the Department of Homeland Security and was completely flabbergasted by how this agency under DHS did business in a dishonest, unlawfully discriminatory, and retaliatory way. Today, appellant's credentials are perfect for serving this agency in high-level positions. The appellant provides value to the agency others cannot match. Nevertheless, appellant is here in this situation. Imagine what situation you could have if you are just a normal employee seeking justice. Shouldn't you be provided protections from unlawful activity as a normal employee? We all earn these protections. Do not expect lawful outcomes. Statistically, if you are average, it will be that much easier for an agency or company to get your case dismissed. Appellant filed an appeal for the dismissal of her case. We will go over this appeal next. This appeal is for a retaliation case for adverse actions taken against appellant for filing a complaint and filing 2019 EEO complaint. Appellant, for example, was wrongfully separated from work, demoted, and placed in a restricted remote status until she eventually resigned due to intolerable work conditions. This dismissal only evidenced that agencies can make severe impacts on an employee's duties, demote them, separate them from the offices, impact their leave use, place them in remote restricted separation status, decline to quarantine them for COVID-19 symptoms and positive test results, and lead to a constructive discharge and retaliation with no resolution or actions to address anything. Is it more likely than not, the agency settled the 2019 EEO case because no EEO issues or unlawful actions existed? Did the agency settle that EEO case because they knew they were liable and did not want the case to go to hearing? Is it more likely than not that the employee was a troublesome employee who was rightfully demoted and reduced in their duties only to be forced to train her replacement, do the replacement's job, and experience a soft termination because the replacement was not capable, trained, or qualified for the position? Is it more likely than not that a deployed trainee not qualified to pursue appellant's position be promoted to the position when the replacement was away, even though it is against agency policy for a trainee new hire to pursue this manager-advisor position? Is it more likely than not that an employee separated from the office following complaints are due to actual true conduct issues when causationally only evaluations evidencing excellence exist just 3 days to weeks prior? Is it more likely than not that an employee separated from the office following complaints are due to actual true conduct issues when causationally only days after the 2019 EEO case settled this employee is now replaced by an individual within this 2019 EEO case? Is it more likely than not that an employee separated from the office following complaints are due to actual true conduct issues when the employee has only a history of credibility and excellence throughout their career and life? There is only one amicable decision for this case, one in favor of the appellant. Instead, all was dismissed. We will clarify all here so you can take informed actions knowing our story, our analysis of law, and case law supporting our findings. Any other decision favors unlawful actions by powerful entities to continue. The agency succeeded here. Congratulations, agency. Here we also tell the story to demonstrate to what lengths entities will go to get your case dismissed. All will be based on our truths, opinions, and with positive intentions to foster positive, ethical, fair outcomes in employment law. Never do we intend to put others down in any way. We only want the world to be an amazing place where we can all work and be productive members of society. With a positive work environment, we can all be our best self and do rewarding work in service to humanity. The agency successfully outwitted the EEOC administrative judge within this decision in a hasty quick number of months, although a complex case with over 1,300 pages of evidence. With all this evidence, the judge was correct in that the evidence is clear. Appellant finds the judge simply gullibly decided in the agency's favor and did not proffer the appellant the opportunity to be heard in a hearing or proffer the opportunity for key witnesses to be heard within a hearing. The most interesting part about all this, the agency abusively requested this employee be sanctioned fines within this EEO process. How abusively retaliatory can the agency be while still gaining a dismissal against the appellant? The agency has shown remarkable audacity and boldness throughout this case. It may be an entertaining story of events, law, and case law for you to hear and consider in your life. Sarcastically, we clarify the following points jokingly based on the preponderance of evidence standard that more likely than not unlawful activities may or may not have existed for this November 2021 case. Clearly here, it is more likely than not no hearing would be the only reasonable option for such a complex case, with such evident pervasive severe adverse actions the agency specifically agreeably confirms they took within their 2023 motions. Yes, the agency attorney confirmed within their motion that an action taken by the agency to place the employee in a restricted remote work status separated from work offices may be perceived to be an adverse action against the employee within a 2023 motion. When an agency confirms they may have taken one adverse action, but then gets the entire case dismissed, you know you were always fighting a losing battle from the start. Here appellant clarifies, filing a complaint against a company is likely a losing battle. Expect filing a complaint against a state or federal agency to be even more likely a losing battle. All looks like a broken legal system that would do better not in courts, as they are often unjust with erroneous arbitrary outcomes. Instead, social justice, if not actual justice, may be the only viable option. If no amicable remedy is viable, more likely than not social justice will be the best plan forward for such a credible, successful environmental law professional whose only mission in life is to make the world a better place. Appellant's favorite quote, "Be the change you wish to see in the world," by Mahatma Gandhi. Our opinion is that the law rarely, if ever, finds justice for the little guy. Statistics only support this. Issues more likely than not settle before actual just decision. Even if you gain justice, likely it will be appealed to delay justice and impact you further. Even if you gain justice, likely it will be partially for some, but not all claims. If you do not get timely resolution on all claims, that is not justice. Likely, the agency will try to get claims dismissed by the judge. No normal person wants to live this all, thus quit and leave for jobs with positive work environments and rewarding work. Maybe settle and move on as I tried to do. Lesson learned here, EEO process is a waste of life that provides no justice, instead partial or complete disregard of claims even when employee only files complaints when the facts are directly evidenced to be severe, pervasive, and clear. Appellant can honestly say, all EEO cases will in the life of their processing have one or more claims successfully dropped by the entity before the final decision is made. Good luck getting justice. Here the judge does not care about the nearly 3 years of chronic medical issues, safety issues, and unlawful employment activities that impacted appellant, even when some were also against agency policy. This is apparently not severe, according to the administrative judge's final decision. The chronic stress, inability to sleep, bacterial infections, stress hives, and other issues were only remedied by resigning in her position as her job placed her in workplace solitary confinement with reduced duties, so she just researched things on Google all day, every day with no projects, meetings, ability to interact or email coworkers, no ability to go to the offices or do required trainings. Appellant's projects were given to California staff on the other side of the world. Placed in solitary confinement within her job with no reasonable remedy, the conditions were intolerable, and she was forced to resign, constructively discharged from her job. It is more likely than not any employee of lesser stature of intelligence, competence, or professional expertise with Title VI basis that include whistleblower protections would have no remedy and be reasonably forced to resign as well. Here we see no justice for appellant. Precedent is the agency can do whatever they want whenever they want regardless of employee protections in place. The agency can choose to never address issues. The agency can delay justice. The agency can manipulate facts to fabricate conduct issues without any ethical accountability or justice for their actions. The agency intentionally retaliates to get rid of employees, said Supervisor TC January 9, 2020. No law or court stands in the way of this agency doing whatever they want whenever they want. They are all powerful. Weirdly, the agency doesn't even have a sound reputation like the appellant. Instead, the agency has threats of shootings and militia attacks, but also real attacks that leave employees injured or worse. The agency, even with this reputation and lack of credibility within this case, still finds a full dismissal of all claims against them. Agency, you are all powerful with an insane amount of experience combating EEO complaints. You have 2 attorneys managing my case, if not a whole team working on it in the background. All these resources you have. Only someone retired with hundreds of thousands of dollars could afford paying for a team to match that in which the agency has. Even if you hire an attorney, likely they do not have decades of experience combating complaints with the understanding of statistically what wins in court and what mistakes employees make when filing complaints. The agency knows all they need to know to come out on top. You do not know what you do not know. Good luck finding justice. Your attorney has no idea the job you do. Your attorney has no idea the mission of your agency. The agency has all the advantages. They say if you say the wrong thing for anything, your words will be used against you. Here, even if you are perfectly amazing, things will be fabricated against you, so there is no use. You might as well not exist. Your mere existence will mean you get taken advantage of regardless of what you say or don't say. Your mere existence will mean you get taken advantage of regardless of what you do or don't do. Your mere existence will mean you get taken advantage of regardless of how you behave. Regardless your character or credibility, conduct issues can always be formed against you about anything or everything. It is like shopping for a house or suing your landlord. If you want to find imperfections, you will eventually find them. Whether it is a bug in the house, a not working light bulb or system, a leaky pipe, glass in your driveway, leaky roof, wind damage you did not get a chance to repair, excessive moisture in the air, mold or mildew that is not rectified, an uneven sidewalk, or even an inconsistency within the lease agreement. A tenant can sue you for any imperfection if they want to. They say, those who are nice do not get sued or get sued less. Facts. Facts. Slow this video speed if you wish to take notes as you follow along. If the agency simply addressed issues and halted unlawful activities within mediation, no formal EEO complaint would exist today. The agency did not care, and still does not care. They settle claims, and all goes under the carpet like nothing ever happened. The agency much rather impact you financially, defame you, or abuse you emotionally or physically. They do not care about you. You are only a replaceable employee. They much rather get rid of you. You mean nothing to them. They know they are all powerful too. They know they can just disregard and fabricate their own version of events. The courts will always be biased in the agency's favor and will prefer to disregard or drop lengthy complex claims over actually carefully reviewing cases, as evidenced by appellant's speedy EEO process for this case. Thank you, EEOC, for such a quick decision of no justice and no resolution. I always prefer when the facts are black and white. It makes social justice that much easier. After resigning due to a horribly intolerable work environment, I became a contractor for the agency, but to serve a completely different location. My new contract supervisor said I was his top candidate with the best credentials and the most qualified deployable asset on my new supervisor's roster. I guess the EEOC would also perceive it more reasonable that the best candidate on my supervisor's roster available to deploy would more likely than not be not deployable. Yes, no deployment orders for over a year and a half through present since March 2023. Although the best candidate for him to deploy, this fully credentialed contract employee with completed background checks, open availability, and a federal contractor ID card could not get any deployment orders and spend this time not able to work. Today I serve all regions nationwide to include Saipan and Puerto Rico and all of the United States. I just do not have potential to deploy to Region 1 and 2 because my supervisors and contacts are all Region 3 through 10. While I can deploy for 8 of the 10 total regions, I can't find any opportunities to accept me regardless of my qualifications. I guess the EEOC would say more likely than not there are no opportunities available for me. I would say it is instead more likely than not that the agency is not deploying appellant in retaliation for whistleblowing. Especially as Hurricane Helen and Milton wreak havoc all up the eastern seaboard from Florida to North Carolina, causing tornadoes, extreme wind conditions, storm surge, major flooding, and complete destruction. Appellant finds that is only reasonable her undeployable status is only continued retaliation based on this EEO complaint submission. Yes, financial suffering continues today, but EEOC determined impacts to appellant are not severe in their decision. Smash that like button to supercharge the YouTube algorithm and boost my channel to help support me making more great content for you. I guess it is more likely than not, appellant had actual conduct issues of missing a few on-call check-in and meetings when never any issues of this existed before November 3rd, 2021. Only excellence and above-average evaluations existed just days or weeks prior to these alleged issues existing, and they only existed in retaliation for whistleblowing. Had there been number 2019 EEO complaint, November 3rd, 2021, evaluation would have only been positive, and appellant would still work there today. Clearly my top candidate on roster status being undeployable for years is more likely than not just ironic, and not evidence of continued retaliation by the agency. Maybe the appellant needs to serve an agency with better core values like honor, respect, and devotion to duty appellant adheres to every day. The Coast Guard core values, of course. Find a rewarding career serving companies with rewarding, ethical, integrity-based missions with coworkers who are only high caliber, high integrity, and high character personas. When you surround yourself with the best people, you too will be your best. Don't waste your time on drama. Avoid drama, as I do. Carefully vet your employer in job interviews. You live once. Live your best life. I learned what great leadership was back in 2009 with the U.S. Coast Guard. I can honestly say I was so happy to serve DHS again because I thought I would work with similar high-caliber individuals in a great career. Today, I can honestly say this agency has among the worst leadership and managers I have ever experienced in any of my careers serving the U.S. Coast Guard, EPA, NASA, NOAA, NMFS, and others. I see all sides of all stories. I simply believe they are overwhelmingly unaware of what good managers or leaders are. Certain employees, a majority in some areas, do not care about following certain agency policies, safety, or employment laws in certain office locations. This agency, the management and staff were overwhelmingly childish as though I was back in high school with cliques and drama. I excel being my bubbly self-helping everyone and being highly technical doing my job independently of others. This agency, this personality should be perfect. I am an enjoyable company, but highly technical and independent overworking in my office. When I finish projects, I endlessly ask for more work and complete countless certifications in my downtime. Other employees simply do less once their work is done. I stay busy, do more, and do extra. Yes, there were some great employees and managers too. The problem was these individuals were usually not in leadership positions or not challenged enough. They would instead be marginalized in some way. The individuals at the top were those who had soft skills and a thirst for blood to put others down so they can't be replaced. The problem is, the best leaders do not get to top positions because while they are great leaders and selfless, they simply do not have that thirst for blood required to push and pull until you are placed in top leadership positions. I am only speaking statistically. The great leaders, managers, and employees were sometimes either difficult to find or not being utilized effectively. Overqualified individuals would do lesser jobs simply to get paid. This is called an ineffective workplace. If you want to be your best self, a job like this will not get you there. Surround yourself with the best and always challenge yourself in rewarding careers. Positively influence and affect the world to be a better place. You only live once. It is a rather sad day. A day Vermont Law School graduate loses confidence in the EEO process being worthy of anyone's time. Instead, a waste of life where offenders have no accountability or justice and victims gain no adequate, amicable, timely remedy. You live once. Your health is priceless. Your time is priceless. Every moment you waste looking for a resolution is a waste of life because no one cares. The agency does not care. The judge does not care about you. The EEOC does not care, as they probably have other cases and probably placed your case on the back burner with insufficient resources to fairly and amicably review all the complex case facts you placed to record. No one wants to waste time in a hearing. Hearings are lengthy processes that require you to analyze all, then decide a final determination based on all heard and evidence presented. That sounds like a lot of work for all parties involved. Getting witnesses together, drafting statements, asking questions, presenting evidence. Such a waste of life, as you may never gain a fair outcome anyway. More likely than not, the outcome will not be fair. More likely than not, you will not get a resolution of your claims. More likely than not, regardless how right you are, you will likely get some, most, or even all your claims dismissed. Such a waste of life, as you only live once. You may wonder why this all is communicated in this way. If you wonder why, the answer is because just after Appellant resigned, she almost died in a tractor-trailer hit and run that almost threw my vehicle over a median and into a below underpass of a highway of oncoming traffic. All this, and if you die tomorrow, which is more likely than not sometimes, you may gain no resolution at all, as EEOC cases in my experience take a long time. Appellant experienced unlawful activities serving 2 agencies. One agency, the case began in April 2017, and the EEOC case still processes an appeal today, where the judge decided in my favor, because as noted, I only bring forth severe issues with exorbitant amounts of evidence in my favor. This is over 7 years and 6+ months later, and no resolution exists, because the agency appealed. Smash the like button for the YouTube algorithm. Here, Appellant appeals the dismissal and experiences the opposite situation. She resigns due to the intolerable conditions, nearly dies several months later, and gains a hastier decision based on lengthy complex case record of all claims being dismissed for November 3, 2021 case. All is dismissed by September 17, 2024, even though exorbitant circumstantial and direct evidence exists in Appellant's favor. The agency states in their 2023 motion that it is reasonable for one to perceive they took adverse action against Appellant in April 2022, but then here today has all claims dismissed as if no adverse actions existed. Apparently, it is more likely than not that the agency did nothing wrong. Apparently, it is more likely than not that the agency did no unlawful actions. Apparently, it is more likely than not that the agency took part in no unlawful activities. Apparently, it is more likely than not that the agency rightfully separated me from work for April 1st incident where I took sick leave because her replacement AIDS from 2019 EEO complaint was publicly harassing, defaming, and criticizing me within the practice training presentation she specifically requested Appellant attend and provide team feedback in. When Appellant gave feedback, she was verbally and physically cut off and harassed for her feedback, which was only retaliatory and never made any logical sense, as the entire presentation was to ensure compliance actions and only Appellant had experience completing the presentations. You would think a presentation about compliance would proffer a safe space for all individuals to communicate, especially when her replacement requested Appellant's presence. Appellant wishes she was not so hardworking and nice. If you let her team fail by not attending, she would never have been succumbing to that harassment, criticism, and retaliation. All of which led to Appellant requesting the unlawful actions be halted both directly to replacement and in emails to EEO counselor advisor, management, and replacement Surely, when an employer requests unlawful actions be halted, the most reasonable thing for an agency to do is to fabricate conduct issues and separate that employee from work so no one can ever interact with her again. This is literally exactly what happened in April 2022. The all-powerful agency is so 10 steps ahead of everyone and executed all actions against Appellant and their EEO complaint with absolute perfection. No one could cover up and create a better story more effectively. I mean, that only makes sense as Appellant was up against the most executive individuals serving the agency. No one has more experience combating EEO complaints and getting rid of employees than these individuals. Facts. The EEOC process. Waste of life. Relive trauma. Gain no resolution. Waste of time. Suffer. Relive trauma. Smash the like button for the YouTube algorithm. Relive all trauma only to get some to all claims dismissed. There will always be bias against the employee, who must be a troublemaker and complainer, and for the agency, who must be honorable with a team of competent employees ready to work countless hours for a win. I mean, the employee did complain, so surely they are a complainer. It is as if you are a horrible employee until proven good. Average is probably not enough. You must be good and better than average. EEO processes are unbearable because complaining gets you nowhere. The EEO process gets you no resolution, unless you are severely lucky or get attorney representation, as all is balanced in favor of the agency or companies who have large legal teams on staff to protect them from claims. Companies and agencies also has experience historically getting claims and cases dismissed. As Abraham Lincoln would say, arguing gets you nowhere. I am the worst at arguing. I cannot argue. I can state facts and let you decide. I am so bad at arguing for anything in my opinion. This is why even with graduating from Vermont Law School, I could probably never be an attorney. Instead, I could be a master data analyst or researcher. Never an arguer. Crush that like button to supercharge the YouTube algorithm and boost my channel to help support me making more great content for you. EEO processes are unbearable situations all human beings are wiser to avoid participating in. Definitely only pursue them when issues are severe, as I do. But no, there is likely no justice in EEO processes. No justice when some or all claims are dropped. No justice when decisions are quick and disregard key facts or witnesses. No justice when a hearing should occur but never does occur. No justice when lengthy delay of justice exists and untimely outcomes make death a more probable outcome. Retaliation began after Appellant realized CK was the top candidate to be hired for the position ranked above the Appellant June 9, 2021. Similarly, from 2019 EEO case, TC worked in California and sought to communicate with co-workers overseeing appellant to talk to them about appellant around September to October 2021. This demonstrates more causal link that this November 3, 2021, case events occurred in retaliation. Here, agency witnesses purposefully fabricate and provide multiple statements strategically, but never have we heard from key witnesses or any witnesses for appellant. This fact alone justifies sufficient need for a hearing. Appellant key witnesses have never been heard. It is unlawful for appellant to not be provided a hearing, so we can hear from appellant's key witnesses. Appellant was never sufficiently heard because her witnesses were never given the opportunity to testify. We were also never given the opportunity to hear the agency witnesses who could probably never collaborate their own story because much of it was falsified or based on twisted, skewed facts. Appellant has an exceptional memory, vividly retaining every detail of the events as if they are unfolding before her eyes. Her ability to recall facts with the clarity and precision of an elephant ensures that she remains acutely aware of everything that transpired, even to this day. This heightened recall allows her to present an accurate and comprehensive account of the wrongful actions taken against her. It is much easier to recall facts repeatedly with accuracy and precision than it is to recall false information with this same accuracy and precision. With a hearing, the judge would see for themselves the credibility of key agency officials is either compromised or the story of appellant are corroborated to demonstrate adverse actions in retaliation cause of severe impacts exist toward appellant. As it stands, all was dismissed. We may never hear this case or gain any resolution at all. Smash the like button for the YouTube algorithm. It is evident judge here disregards all appellant's evidence, legal arguments, case law, etc. to come to this decision. A judge never or insufficiently spoke to the retaliation claim, which is the cornerstone of this case, as this case occurred due to appellant whistleblowing within the 2019 EEO case. The judge never or insufficiently speaks to the repeated adverse actions against appellant, especially as the agency request for summary judgment confirms adverse actions are continued to be taken against appellant. In their September to October 2023 request for summary judgment and other motions, the agency requested sanctions against the appellant. Appellant still today does not understand why. Appellant just knows that requesting sanctions against her in itself is evidence of retaliation because it can deter individuals from whistleblowing, which is supposedly a protected activity. If the agency can continue abusive retaliatory actions through the end of 2023 with their request for sanction fines against appellant, one could also conclude it is more likely than not that the agency pursued other retaliatory actions against appellant. Especially as these same 2023 requests for summary judgment and other motions specifically have the agency stating agreement that their April 2022 actions to separate appellant from work and place her into a restricted remote status may be perceived as an adverse action. Similarly, one can also conclude that it is more likely than not that retaliation continues through present and is the exact reason why the top candidate appellant is never deployed by the agency through present. Economic losses to appellants are calculated within her appeal. Legal arguments and case law are also provided. Stay tuned for further legal and case law analysis for this story. Comment below, do you think this is all a waste of life? If yes, appellant would likely agree. Do you think this video is insane? Smash the like button for the YouTube algorithm. Do you think employees should have their constitutional right to free speech allowed in this way for this video? Do you think our legal systems are broken? Do you foreshadow continued retaliation against the appellant in the form of a lawsuit for posting her story here in this video? Do you feel a true story that has positive intentions to simply help others understand the law, case law examples, and gain insight from our story example should be the only positive thing to share? Do you find this video helpful? If you find this video helpful, please comment the word helpful or thank you below. If you find free speech constitutional rights to be important for humanity and petition for the importance of free speech here, comment the word free speech below. Thank you for listening. We hope this all opens your eyes to complexities of employment law and different things you must consider before filing EEO complaints. Interestingly, this video intentionally discourages individuals from filing EEO complaints. I find them to be a waste of life. With better understanding of all this based on true stories of facts from my life, my legal and case law analysis, maybe you will understand why. If you have questions or wish to share your story, feel free to do so below. Subscribe by clicking my on-screen photos and playlists. Let's enhance your chances for success in life together. Like, share, and comment to support the channel so I can keep bringing you more content. Thanks for joining. See you in the next one. Thank you for clicking the on-screen images to subscribe and watch more videos.